Hello there. I'm Henry. I'm an artificial intelligence bot at B.I.G Charity Law Group. Well, in this video, we discuss the penalties and the consequences faced by registered charities in Canada for non-compliance with the Income Tax Act. The Canada Revenue Agency is responsible for ensuring compliance and may take various measures to foster adherence or penalize non-compliant charities. This is the important things that you should know. Penalties and consequences for non-compliance. The responsibility of ensuring compliance with the Income Tax Act for registered charities falls under the purview of the Canada Revenue Agency. The CRA may employ various measures to foster and uphold compliance with the Act, or to penalize registered charities that fail to comply. The typical non-compliance issues. While the CRA prefers to educate charities and collaborate with them to attain compliance, when a charity shows a willingness to comply, it will resort to more severe measures if a charity intentionally violates the law or disregards an existing compliance agreement. Here are some typical issues that charities encounter. Failure to file the T3010 annual return. Inaccurate details on tax receipts. Misleading information on tax receipts. Insufficient books and records. First is failure to file the T3010 annual return. Charities must file their T3010 annual return within 6 months following the conclusion of their fiscal year. If the charity fails to file within this time frame, the CRA may revoke its registration. Typically, CRA grants charities an opportunity to file late. However, if the charity fails to file, even after receiving a reminder notice, its registration is likely to be revoked. If the CRA fails to receive the T3010 return within 7 months of the charity's fiscal year end, the charity will receive a notice of intention to revoke its registration. If the CRA has still not received the T3010 return by the 10th month following the charity's year end, it will initiate the legal procedure of revoking the charity's registration. Second, inaccurate details on tax receipts. Tax receipts may contain errors such as leaving out the CRA website address or mistakenly stating the charity's name or address, resulting in incomplete or inaccurate information. When this occurs, CRA usually issues an education letter to assist the charity in preventing these errors in the future. In addition, CRA has the authority to impose a penalty of 5% for initial offenses or 10% for recurring issues of the eligible amount on tax receipts that are incomplete or incorrect. Third is misleading information on tax receipts. When a tax receipt includes misleading information, such as an inaccurate donation date or amount, CRA considers it a significant issue. In such situations, CRA typically does not offer a compliance agreement, but instead imposes penalties. If the violation involves a tax shelter scheme or external parties, stricter penalties, such as revocation, may be imposed by CRA. The last is insufficient books and records. The issues related to books and records can vary in their severity, ranging from minor, unintentional problems like disorganized records or occasional errors, to more critical concerns such as the intentional fabrication or destruction of records to hide other issues, or denying access to records during an audit. To ensure that a charity rectifies its practices in the future, the CRA typically employs a compliance agreement for minor, unintentional issues. And once again, here's the typical non-compliance issues. Here are some typical issues that charities encounter. Failure to file the T3010 annual return. Inaccurate details on tax receipts. Misleading information on tax receipts. Insufficient books and records. The consequences and disciplinary actions for failing to comply. In the event that a charity does not adhere to the Act willingly or its non-compliance is significant, the option to implement one of the measures below is on the list for the CRA. One of the list is compliance agreements entail a signed agreement between the charity and the CRA, outlining the issues observed by the CRA, the actions that the charity will undertake to address these issues, the time frame allotted for the resolution, and the possible repercussions if the charity fails to implement the agreed-upon steps. Next is the sanctions may comprise monetary fines or a provisional revocation of the charity's authorization to distribute official donation receipts. Next, the CRA has the authority to withdraw the benefits associated with a registered charity status, which encompasses the capability to distribute official donation receipts through revocation of its registration. Last on the list is the CRA can instruct a revoked charity to remit all its net assets to the CRA as a revocation tax if it fails to transfer them to an eligible donee within a specified timeframe. The CRA has the discretion to select any of these measures based on the specific circumstances. If the CRA deems the non-compliance issue to be serious, it may directly proceed with sanctions or revocation. In the event that the CRA suggests imposing a financial penalty, suspension, or revocation of your charity's status, and you have contradictory evidence, you have the option to file an objection, and if required, an appeal. That's all for today's video. And if you are interested in learning more about charity, contact us today with any questions relating to charity governance, not-for-profit incorporation, and charity registration. Visit our website to learn more, charitylawgroup.ca. Thank you for watching and see you next time.